Good evening. Welcome to this evening's Public Safety and Judiciary hearing on possible changes to our Columbus City Code. I want to remind everyone, if you are interested in speaking at tonight's hearing, to please find a speaker slip at the door of chambers, fill it out, and my legislative assistant, Devin Perros, will be accepting speaker slips until 5:30. I want to thank the following individuals for being here this evening. Our Director of Public Safety, Mitchell Brown, do not believe he will be able to attend us this evening. Deputy Director Dan Giangardella, Assistant Director Amanda Ford, Support Services Administrator Ramona Patz. And I don't see any of my colleagues here this evening. I want to give a little bit of background in regards to tonight's hearing, in which we will cover 4 different code changes. We are revisiting Chapter 523 to Commercial Sales Code to clarify the definition section as it relates to the City of Columbus and privately owned properties. Our changes will include a reference to the race event permit created in March 2013, and we will make changes to Chapter 523 that ensure our code is consistent with the Ohio Revised Code and is constitutional. We will also discuss changing the notification requirements for false fire alarms in Chapter 597, and we'll look at modifying the invoice date for fire prevention and inspection fees found in Chapter 2502 to better adhere to modern business practices. And finally, we will be discussing repealing several chapters of Title V, the Business Regulation and Licensing Code, that are outdated or unenforceable. So we'll get started with turning the hearing over to Assistant Director Ford, as well as Ramona Patz from Support Services, to provide a presentation of these proposed changes to the Columbus City Code. Thank you. Amanda, I will turn the floor over to you.
Good evening, Councilmember Mills. Thank you for the opportunity to be here this evening to present the few proposed code changes and several codes to be repealed. As you are well aware, Ramona and I, along with your staff, have been working over the past year to update several codes that the license section has the responsibility of licensing and enforcing throughout the City of Columbus. As part of our efforts to review all these codes in Title V, we quickly realized there are numerous issues. Many of the codes are no longer relevant. Several codes had the licensing requirements and/or fees repealed back in 2003, meaning the license section is no longer issuing licenses or doing enforcement for those sections, and some of the codes are now adequately regulated by the state, voiding the need to be regulated by the City of Columbus. As we begin to prioritize codes, we decided it made sense to start with these codes that were no longer needed and should be repealed. As I go through each of these codes this evening, I will do my best to provide a little history and provide an explanation as to why it should be repealed. Once the proposed changes have passed council, we will present updates to Section 501 that govern the license section to reflect the changes presented tonight. As I go through each code section, feel free to stop me at any time and ask questions, since we'll be jumping around a little bit. The agenda for tonight's hearing: first, we'll go through the fire permit to address some billing issues with fire permits and inspections. Next, commercial sales. We're just recommending a few minor changes, but it'll mainly handle that confusion of private and public property. Next is the alarm user code, dealing with how we notify users of false alarms. And then finally, we'll go through all the codes to be repealed. First up is Section 2502.077. This section of the code refers to the billing for all fire permits and inspections. The code, as it is written, states that all payments are due by July 1st and that all outstanding payments after July 30th are considered delinquent. This basically means that if a permit is issued or an inspection is completed in January, payment is not due until July 1st. The code is being updated to reflect current business processes and allows invoices to be sent throughout the year. It is common sense to assume that if an inspection was completed on October 1st, the fees must be paid by October 31st, and anything still outstanding after 60 days would be considered delinquent. As you see, this code now reads that fees are due 30 days after invoice date, and inspections are considered delinquent after 60 days. So you can see up on the slide that the changes are made in red. So it's pretty simple, just stating that the 30 days after. Any questions about this one, since this is the only code change we're making to this section? All right. Next, we'll move on to commercial sales. The commercial sales code was updated in July 2012, but there has been some confusion over private property. when we worked on the code, we felt that private property was indicated in the definition as stated, any street, road, alley, doorway, sidewalk, vacant lot, or other tracts of land, with vacant lots and other tracts of land being private property. Sitting on that committee myself, we had a full understanding of what that meant, but it's been very confusing to the public and those seeking a commercial sales license. So we'd like to clean up the definition so that it's clear that a commercial sales license is required for anyone peddling, soliciting, or canvassing on any property owned by the City of Columbus and all private property. We have added one additional exception to the code, and we'll go over it in a moment, but it addresses individuals selling on their own private property. The next definition change was we added race permits to the definition of a special event, as often those individuals who are part of a special event are not required to obtain a commercial sales license because the event itself has a permit. And the final definition was adding the definition of privately owned property. So for clarification, that's anything that's not owned by the City of Columbus is considered private property. In Section 52303, this is the exemption. Basically, it addresses the issue of individuals selling on property that he or she owns. The individual must be able to provide proof of ownership of that property. So an example, if I'm holding a yard sale or my lemonade stand in my front yard, I'm not required to obtain that commercial sales license as long as I'm staying on my own private property. 52304, the license application section. In three different parts of this section, it requests a social security number. The city can no longer deny an individual a license because he or she refuses to provide a social security number. So as we continue to update other codes, we'll make sure this is removed from any of the codes as we move forward so we can abide by the law. And then 52314, prohibited acts and hours of operations. The code has always stated that individuals may not peddle, solicit, or canvass door-to-door between the hours of 6 p.m. and 9 p.m. to be respectful to residents, but we're now recommending that that be changed to between the hours of 8 p.m. and 9 a.m. to avoid potential constitutional issues. So these are all the proposed code changes we have for commercial sales at this time. Obviously, it's something we'll continue to review if we still have issues with confusion over private and public property. Next, we have Section 597.16 of the false alarm determinations. We are only recommending one small change to this code, and it's basically the priority to review. Let me start all over, sorry. We're recommending one small change, but the false alarm system and dealers and users code is on our top list of priorities for reviewing the entire code. So we're hoping later on this year we'll be able to start a review of the entire code, but we would like this one small change so that we can change how we notify individuals that police or fire have responded on a false alarm. So as you can see in red, we're adding that any person receiving a false alarm notification will receive notice one of three ways within 5 business days. First is posted notice. We have worked with police and fire to create a door hanger that you can post notifying the resident or business that police or fire have responded to a false alarm report, and the license section will be following up with them. I'll go ahead and flip one slide ahead. You'll see this is basically what the door hanger will look like. Obviously, it'll be a little bigger and it'll have a little hook on it, but obviously it's got our logo. It'll have the firefighter or officer's name who responded with their badge number and assignment so that there's a number if they have any questions, they can call the license section potentially before they are notified by the license section. The second way they can be notified is through email. If the license section has an email on file for the alarm user, they will send them an email notifying them of the false alarm and any fees that are due. And then finally, U.S. postal mail. So if they don't have an email address, they will receive a letter from the license section stating that they have, police have responded to a false alarm and that there are fees due. So that's the only code the code change that we're recommending to the false alarm users at this time. Now we will move on to codes to be repealed. Obviously, many of these codes were created years ago. Obviously, different forms of the industry at that time. So the first code that we're recommending is 511 Astrologers. This code was created, I believe, in the late 60s or early 70s. When I go into Muni Code, there's not an exact date of when the the code went into effect, but based on what I read, it was in the late 60s, early 70s. So an astrologer is defined as any person who can accurately compute and set up a map commonly called a horoscope of zodiacal and planetary positions for any specific moment and place accordingly to the rules of astrology, and who can explain and interpret such map according to commonly accepted astrological principles, such as may be found in standard textbooks on the subject. So obviously that's a mouthful right there, just trying to say the definition. But it was determined years ago that licensed officers aren't qualified to determine who is an astrologer or who is not. So majority of the code was repealed in 1997, and the fees were actually repealed in 2003. So obviously no enforcement or licenses have been issued since 1997. Obviously, it's a tough field to regulate, so I would encourage anyone seeking this type of service to just make certain that they're using individuals who have a certification or accreditation through or have completed coursework from a reputable institution. Next is 515 Bondsman. This section was created in 1956 and refers to the licensing of an individual or company who provides bail bonds, recognizance bonds, and court bonds. In the code, it states that the individual or company must also get a state license. Our code is fairly vague and only states that an individual must provide a receipt and show burden of proof and pay the licensing fee. Bondsmans are currently highly regulated by the Ohio Department of Agriculture's Enforcement Division with a more comprehensive code. So for this reason, no licenses have been issued or enforcement done in the city. So it's pretty simple. The state, fortunately, regulates this for us now. Next, 519, itinerant wholesale produce vendors or produce dealers. This section was created in 1952 and addresses an individual selling produce on a temporary basis from a cart, wagon, truck, or other vehicle. The license fee was repealed in 2003, so no licenses have been issued. And there was kind of a sister code that went along with this titled Wholesale Produce Dealers that was repealed in 1982. So currently the sale of produce is addressed in the Commercial Sales Code and the Community Market Code, so there's no need to have a separate code specifically for itinerant wholesale produce vendors. Next, 533 automobile parking lots. Once again, I couldn't find an exact date for when this code was created, but it was created to minimize the amount of dust and debris caused by large gravel parking lots. The code requires spraying of the lots and just keeping the gravel off the adjacent streets or roads. After some research, I found that in the mid-'80s, legislation was passed that required automobile lots to be a hard surface. So basically, they had to be concrete or like blacktop. So basically, the code's no longer applicable. No licenses were ever required for this code, and it's more of a zoning issue than it is a license section issue. Section 537, jewelry auctions. Obviously, this section addresses jewelry auctions. The Ohio Department of Agriculture Enforcement the Enforcement Division also licenses all auctions and auctioneers. So the city stopped issuing these licenses and repealed the fees back in 2003. I did call ODA and did find it interesting that there are no regulations for online auctions. And obviously they're becoming more and more popular. So while it's a concern, as we know, things online are often tough to regulate. So I know that it's something that they've looked at, but have not been able to move forward with any regulation to address those online auctions. 538, ophthalmic lenses and eyeglasses. This code was created in 1968 to address advertising as it relates to eyeglasses. While the code is vague, it states that all advertisements must be clear and read in a manner as to be clearly understood. The ophthalmology field is obviously highly regulated by the state and includes statements about advertising in the section of the Ohio Revised Code. So no license was ever required by the city to sell eyeglasses, and no enforcement has been done in at least the last 18 years. Obviously, going through these codes, I contacted the license section and sat down with them just to get some background information on some of these. And so we have about 18 years there that we know that nothing's been done with this code. And like I said, it's all regulated by the state at this point. 557 exhibiting objects of curiosity. This has probably been the most interesting code, trying to figure out what exactly it means. There is no definition of an object of curiosity in the code itself, but it's my understanding that it refers to things that you might often see in a circus or magic tricks, something you're paying that fee to see. So you pay the fee to see behind the curtain, kind of situations like that. So it could mean several things. So majority of these instances are currently covered under City Code 563 that addresses shows, carnivals, and circuses. The license requirements and fees and exemptions were all appealed in 2003. But I did some research trying to get a definition of this, and it is in the Ohio Revised Code, but the definition is very short and just says, exhibits of nature or artificial curiosity, horsemanship in a circus where a fee is paid. So obviously very vague definition, but obviously something we're not enforcing at this point. And finally, 562, motion picture films. This section was created in 1961 to establish a motion picture review board that had the ability to review any picture playing in the city and determine if it violates state law or Columbus City Code. The code does not state what potential laws or code violations there may be, and it's very basic, stating that the board had the ability, as long as they paid for the movie, they could go view a movie once it was out. The city has taken an interest, obviously, in wanting film productions in the city and created a commission to evaluate motion picture productions. So the code is outdated and no longer needed now that we have a commission to handle that. 581, private utility company rates. This section was created in 1984 and requires public utility companies to submit rates and schedules for services to the city clerk's office. After checking with the city clerk's office, they can't ever remember a time when those rates were ever submitted to them or in need for that to happen and maintain. So obviously the Public Utilities Commission of Ohio regulates utility companies and would have this information. It would not be required to be reported to the city. Yes.
So the co-op utility companies that have spurred up that would also be part of Public Utilities Commission?
I'm sorry, the what?
The co-op type utility companies?
Yeah, that's what, it all falls under PUCO. So, yeah, that's what the clerk's office didn't even understand, like, why it would be reported
They're turning
to
them into them?
Yeah, so they
Okay.
weren't sure why it was ever written into code as to why they would need to report that information. But that was probably before maybe PUCO had started doing all the regulations.
Okay,
So.
thank you.
And finally, 595, community antenna television systems. This code was originally Section 596, but was repealed in 1978. It was later updated and passed by council in 1996. The purpose of this code is to provide requirements for the operations of any cable communication system in the city and the issuance of permits to operators of such systems and the policies of the city. There are also several requirements dealing with the use of public right-of-way for the installation of poles and wiring. So after a little research trying to figure out what the basis of this goal was, I found out that the license section has not issued any 595 permits for the past 6 years. So there were two things that happened. Public Service issues a 910 permit dealing with the use of public right-of-way that has all the same requirements necessary to obtain a 595 permit. So if you get a 595 permit, you don't have to pay the license fee for the 910. And if you have the 910 permit, you didn't have to pay the licensing fee for the 595 permit. So companies stopped getting the 595 because it was a $75,000 non-refundable application fee. So all the companies just went to the 910%, the 910 permit that cost us roughly $1,000. And then secondly, in 2007, Governor Strickland signed Senate Bill 117 that required all cable companies to apply for licenses through the State Department of Commerce. So prior to this going into effect, the law required each company to obtain a local permit in the municipality or township where they offered their services. So with the passage of this law, it voided Section 595, but cable companies are still required to get the 910 permit before they install any poles or wiring. So finally, on to the last code, which I will turn over to Ramona because she's been more involved with this project. So it's 571, bicycle registration.
Councilmember Mills, this was Currently, there's a fire code that states that everyone should register their bicycles. That has not been used in years. So what we're going to do is we're going to repeal Code 571, and we're going to create a new way for bikes to be registered in the city of Columbus. I've been working with the mayor's office, OSU, and CODA to create a bike registry that's going to work through our new medallion system in the license section. It'll be free registration. There's going to be little RFID stickers that'll go on people's bikes. It's also going to help OSU and the City of Columbus Police because we're going to have an online app where they can go online and check the vehicles, if the bicycles, if they're stolen. So we're repealing an old code, and we really don't need to have a new code because we're going to have a registration process within the license section's online webpage.
Ramona, can you tell me about any connection with the leads online? Because some bikes are made out of metal that would show up maybe at a scrap metal dealer or anything like that. So if this license appears on the bike and it's turned into, say, a scrap metal dealer, is that something that we could have them flag because it's licensed and registered? And that should match? Because if it's part of a junk pile on a shopping cart, tires are off, but it's now a licensed bicycle, it has an owner, that there's a way to tell if that actual bike or the frame itself belongs to someone besides the person submitting it for scrap.
I became aware of that at the very tail end of this registration situation, and I contacted George Speaks, Deputy Director George Speaks, about it. I know he's been heavily involved in that. And we're waiting for the budget to be approved so we can start some more processes to add some more applications, and I was going to look into that as a connection as well. I don't know if we could get let the scrap dealers be able to get online to check it, or if I need to work through the unit in the police department to get them online with it as well.
Okay, if you could follow through on that and then let my office know what the outcome of that is, because I witnessed the bike on top because taking off the wheels and that, because really you just turn it in the frame, and then that then leaves some recyclable material that they could get paid for. But if that license is there, that should indicate particularly it does not belong to that person. And I don't know what the sticker is going to look like, if it's just going to have a number. And then you would have to, as you work through that process, if you could please keep that in mind as we worked so hard on the leads online, trying to contain everything we need to return people their property, and bicycles shouldn't be excluded.
I will.
Thank you.
So that wraps up our overview of proposed changes and proposed codes to be repealed. We believe that while we presented several changes, they are more of cleanup items, and will help us moving forward with our mission to bring Title V sections up to date. Once again, thank you for the opportunity to present this evening, and I'll happily answer any other questions that you have.
Thank you, Amanda. I appreciate it. And thank you, Ramona, for the presentation. I believe I have no other questions regarding this. As we talked about, this is a cleanup and making sure everything's updated. We are now at the point of the hearing for public testimony, our last order of business. I don't see any speakers, have not received any speaker slips as of to date. So I will move to closing remarks regarding tonight's hearing, and thanking you and all of the folks who participated in making the presentation possible this evening. I know it's important that we continue to re-examine our codes from time to time to ensure that it reflects modern practices and remains relevant. Signs of technology continue to change, and we have to change with it to make sure that we can continue to provide consumer protections for our citizens, and also being customer friendly in the license department and not bogging our license department down with unnecessary codes and permits of which we have no use for. Again, I'm glad that these changes will not only make sure that the code is consistent, but also consistent with state law, but also constitutional. And again, hoping for more consumer-friendly practices. I want to make sure that I inform everyone that we're looking to pass legislation related to tonight's hearing next Monday. Actually on Monday, February 3rd. And if there are any other questions or comments, please feel free to contact my office. And with that, I wish everyone a good and safe evening.